Okay. Everyone has grabbed a cup of coffee, some water, etc. We're about to proceed with our final session, and we conceive this session as a conversation panel. I described it with a metaphor. We've been shooting a firework these 2 days, and it's time now for the bouquet final, for the finale, okay? So, here is how it's going to work. We didn't ask the panelists to prepare and give a paper or remarks. We like this to be a conversation. We will try as much as we can to engage with the room. But of course, you can benefit of being here, sitting here to make remarks on a topic that is dear to your heart. And just to throw a general question at you to start the discussion, we've been sitting there, standing sometime for those who presented. Is there anything particular that you learned or discovered during these days, or that surprised you did not expect? Who likes to give impressions? We can go this way, whatever way, whichever way you want. Who likes to have a start?
I was told never sit on the end.
Never sit on the end. There you are.
No, you misunderstood. I was told not to sit on the end.
Always count on your friends to betray you.
Well, I'm surprised what a great conference this has been. I'm surprised at the gamut of questions we've looked at: AI, the history, the periodization of the civil code experience here in Louisiana, thanks to Agustin, and so many things. I won't even go through. I lost my notes. I had no, you won't believe me, but I took notes through everything I heard yesterday, and promptly left them on a table. So I haven't got necessarily anything prepared to say. But it was the first time I had ever heard of the periodization that was chosen by Augustin, and that struck me as very interesting. If I had to say something about what the terminology he uses and the periods that he divides our law into, I was struck by the fact that his first period is called archaic. Now that sounds very old. We're only on a 200-year or so time span for Louisiana, and I wondered whether or not there could be another word, because the period that is regarded as archaic, let us say, begins about 1803 or 8 or 25 in there. And what is archaic about it? Well, you have a situation in which you have no practicing bar to start with. You have judges brought from the outside. Nobody from the inside. No Creoles. You're inheriting, I'm having to look into the eyes of Augustin, and I'm not criticizing Augustin. It's wonderful that you've come up with these. But we have a situation that I feel maybe there's another word rather than archaic, and the reason is this: at that point you're inheriting an unrepealed Spanish system. It is still law, and I think everyone would agree that throughout this period, and maybe until at least 1828, you have no repeal or attempt to repeal Spanish law. And you have no trained lawyers, no university-trained lawyers. You have no law schools. You have no books. Some of the texts can't be found. Claiborne said, he told Madison, I can't find a copy of Siete Partidas anywhere in this state. It wasn't a state, in this territory. So none of the accoutrements of the civil law, the usual civil law, existed at that time. The Spanish had done without lawyers, almost without lawyers. Only one trained lawyer at a time, usually, was in this city. One trained lawyer. That's not quite accurate, but there were some people who seemed to function as lawyers, but they were attached to the court and had to be approved by the court, and they would become mandataries. So this is a primitive period for, I would say it's an apprenticeship period. We're just learning. There's a flood of common law lawyers who are outnumbering the French lawyers and Creole lawyers. There's a flood coming in, like Livingston, but not as good as Livingston. So many of them. This is just an initial comment that as interesting as this periodization is, and another thing is, you labeled one of the periods post-classical, but you cautioned us that doesn't mean it's declining. That doesn't mean it's declining. And yet it suggests that there might be decline there. But I think you're saying it's really moving upward into a self-sufficiency. Or am I in the right period? The self-sufficient period, where we have a literature, we have law schools, we have institutes, we have institutions. So I don't think post-classical suggests the right direction, but I have no improvements to make there.
I can't resist making a note, and I will speak under the control of my moderator across the table. In Greek history, archaic is what precedes the classical period. That's a use, and I think in that sense, the word may be right. But certainly, Vivian.
So to change the subject slightly and also to engage with the audience if the audience feels a desire to respond, I was very interested in the extent to which translation came up, which is, of course, a natural subject when it comes to the Louisiana Code. Those of us who are comparatists may think of ourselves, and I think of myself this way, as principally engaging in the activity of translation. I think comparison itself is an act of translation. And I wonder how many of you might agree with me. And to go to a step even more general, if you think of writers like Lakoff, he is either a linguist or a psychologist or both. His argument is that thinking is translation, thinking itself. But certainly if you think of comparative law, it is a translation from what one might think of as one semiotic system into another, with all that implies.
Okay, well, thank you, Olivier. The only reason I was invited here is that Olivier knows that 20 years ago I wrote an article. 20 years ago I wrote an article on bijuralism. And that was because the International Academy of Comparative Law, which was meeting at Utrecht, Netherlands that year, had made that a topic on which every country in principle had to send somebody to talk about. And so I got involved with Louisiana. I thought that was compelling. And I'm going to pick up on what Vivian was just saying, because that article, which is of no interest to anyone, it turns out to be assigned reading in a course at Princeton University, where my wife teaches, but it's not her course, okay? My article is not assigned reading in her course, but it has been used in a translation course at Princeton every year for the sole purpose of demonstrating how translation presents challenges differently in different fields. And this was their law example. Now, I actually am very intrigued by the translation angle, and one of the things I observed and reported on in this ancient article was the various ways in which Louisiana courts appear to have been trying to somehow reconcile in various ways the French and the English version of a civil code provision. I think those of you from Louisiana know all the cases that I read and cite, but it became very interesting to me that at one time, it appears, back early in the 19th century, that the courts were trying, at one point said, well, we have to be liberal, so either translation may be relied upon. And then somewhat later, as I recall, the gears shifted a little bit, and the approach was we have to do our best to give full effect to both renditions of the term, which turned out to be extremely difficult, to give full effect to translations, to versions that are not, in fact, reconcilable. And then eventually, to my amazement, I learned, and you reported this earlier today, that even after 1870, when the Civil Code was official language was English, the term in the code that was at issue was to be interpreted in accordance with the 1825 code because not enough had changed to infer that the legislature wanted to abandon. I think that's what you have told us. And then I found that very intriguing because English is the official language, but the English language version of the term in question is going to be secondary to what the term meant in 1825 in French. Now, I give you that as an example, just to say that I thought that was a big challenge there for a court. And as an arbitrator, when I have to apply a body of national law, I know what the challenges can be. But to answer your question, finally, I walk away from this conference just really overwhelmed by the number of dimensions of the challenge that your tradition here, embodied in the Louisiana Civil Code, is facing. Whether it's coming from the Uniform Law Commission, or whether it's coming from its having to adapt itself to being part of a country where 49 of the other jurisdictions are common law. I won't go through them all, but these 2 days, for me, have devolved into a series of fascinating and serious challenges. In a way, I envy you. Because to a degree, challenges are to be welcomed. But in a way, I pity you. No, but seriously, it's an enormous challenge for you to maintain the integrity, it seems to me, of the Louisiana Civil Code in the circumstances in which, the larger circumstances in which it is operating. So that's my key takeaway.
Thank you, George. And when you talk about beating us, we are a bit more than 4 million people, but think of former colonies like Vanuatu, where they have 200,000, and they wrestle with the civil law, the common law, and customary law that they try to keep alive. So we're not that bad off. Thank you.
What strikes me so much is over the last few days, in a very real sense, virtually every conference session has been dealing with the effort to deal with the further development and evolution in a positive way, or whatever the topic in question may have been, whether it's the use of language, whether it's the character of the statutes, the Civil Code in 1825, whatever it is. They begin at a point in time and they move forward. No one actually, I think, did that better, frankly, than our beloved speaker for the Tucker program. And I have somewhere here the title of his talk, which is A Bicentennial Approach to an Exegetical School of Private Law in Louisiana. And what's striking is he has taken a series of categories that are basically time and performance determined, and he's asked you to stay with him as he goes through those series of categories. And what's so striking is those categories, in my judgment, are also fully applicable to the Center for Civil Law Studies, in which I must confess I have enormous interest, because I had the privilege of being here, hiring this fellow way to the left, certainly one of the best appointments I've made here or anywhere else, and watching this thing move as well, as magnificently as it has, and being beautifully symbolized by the character of the speech that was offered by Augustin Parise when he gave the Tucker lecture. He broke this time period down into issues of codification, conceptualization, exegesis, semination, and cultivation. And then he had subcategories for each of those, and I really, rather than repeat his full speech or even try to achieve the elegance that he achieved, I urge all of you who haven't heard the speech to have an opportunity to see a copy of it. But in this case, as in all the others, we're beginning with a problem. And the issue is, how do we solve the problem? And the issue also has to begin by defining, well, what is the problem? And what are the goals pursuant to which it's going to be achieved? And what are the mechanisms pursuant to which it's going to be achieved? And I'm struck, as I look at the life of the Center for Civil Law Studies, of a very similar kind of movement from dilemma, concern, a fear that something could be perhaps more productively produced than we had at a certain time, and then what we did about it. In my judgment, I came to LSU in 1998. The Center for Civil Law Studies was formally established, according to a book by Lee Hargrave, in 1965. I came down in part, I came here in part from Vanderbilt, in part because of my excitement about the fact that this is in my view, is a bijural school with a set of remarkable opportunities and capabilities associated with that bijuralism. So when I came down, I expected to see a Center for Civil Law Studies as active, vigorous, moving forward, etc. I didn't see that. What I did see was a wonderful arrangement whereby professors on the faculty were participating with respect to the Law Institute and its activities. So the activities of Fanasi, of Simonides, of the other professors that were very distinguished here and are very distinguished here, were being directed to the reformation of a positive act, the actual legislation here in place. They were themselves, in addition to that, outstanding scholars. So they carried the force of this scholarship and used that scholarship in the direction, though, of modification of the Civil Code. This was a major contribution. This was a wonderful statement about, to that extent, about what the school was prepared to do in terms of addressing the question of the fact that we're in a mixed jurisdiction. But it seemed to me that something more was necessary. Not only those fellows were extraordinary, and their performance was outstanding. Of course, Professor Levasseur, I put in that category. I put Saul Litvinov in that category, etc. But I was wondering about what was happening in the classroom, and to what extent were the possibilities of bilaterality, if you want to call it that, being explored in the classroom as well as outside of the classroom? What forms were they taking? What was the institutional structures at the law school that might help this? And I found out very quickly that there were a number of resistances, quite legitimate ones in some ways, resistances to moving more aggressively than the very good thing of having Thanasi, Simonides, etc., doing excellent kinds of reformations of the Civil Code and such. But I noticed that they were doing that work under the aegis of the Louisiana, I think I'll get this right eventually, State Law Institute, which is wonderful. It's terrific that they contributed those efforts in that institutional mode. But I wasn't seeing very much happening with the Center for Civil Law Studies, and I was concerned that the extent that scholarship here would be so narrowly focused on statutory or code revision, that very important questions, jurisprudential and other questions that merited attention, were simply not being addressed, or in particularly not being addressed in a focus that would be useful in the classroom. So I then looked carefully at what McGill was doing. I looked at what the University of Montreal was doing, other schools were doing, that had a cast of bijuralism in what they were about, and then met with the faculty over basically 2 years. This was about 5 years prior to, excuse me, jumping here too quickly, Moreteau's arrival from Lyon, one of the greatest things that I think happened to the law school in this 20-year period. And you know, what I found is that in effort to seek to reconsider the curriculum, to reconsider what vehicles might be put in place to move more strongly in a bijural direction, they're very difficult. Because, I mean, to begin with, there were very, very fundamental differences in the faculty. As long as the professors were doing that work and making that choice to write those articles, there was no cold cost, in a way, to the students, in that sense, of the institution, because they were paid, they were doing this work, it was important work. But the minute that you started talking about changing the curriculum or modifying the curriculum or addressing the intellectual challenge of what is it about the bijural potential components of a curriculum here, you got into a lot of trouble. Not trouble, a lot of difficulties. What were the difficulties? Well, number one, the civil law faculty became very concerned that their teaching loads might be significantly increased by virtue of our going that direction. And there's no question that the civil law faculty here teaches many, many more contact hours than professors typically do at other institutions. So they had some concern. I thought they would be thrilled to move actively in the direction of a bijural investigation system. I'm not sure that that actually was the case. The Center for Civil Law Studies was really basically producing the specific scholarship of the individuals associated with it, rather than some kind of a program that might involve the students, etc. We had the problem at the time, we had 90 hours of studies at this law school at a time when the APA only required something in the range of 68 or 70. So our concern about also adding or modifying the curriculum presented the issue of overloading the curriculum and having too many courses for the students, and that might be problematic. There was also the question of evaluating the student body. Some of the student body are from Louisiana. Most of it, particularly at that time, most of the students are from Louisiana. That is a real plus. Why is that a plus? Because they're going to practice in Louisiana. That gives them an economic reason for being interested in, whether it's intellectual or not, it certainly gives them an economic interest in being real sharp on the civilian law statutes and how they operated. Okay, then we have a group that's out of state. At that time, it was a smaller percentage of our students, and the question for them was, were we going to include them in what ultimately became a double-degree program? People from out of state coming here and then going back to their own state or other states in order to practice law. And that was an issue of some real concern. And finally, we had the question of bringing foreign students here. So we had resident students, we had non-resident students in the United States, then we were possibly thinking about, and have done, thanks to magnificent work by Moreteau and his staff, we now have an extraordinary traffic, if you will, and very, very talented European students. But so that each of those three things had to be worked out. The question of allocation of teaching credits had to be worked out. Trying to determine, was there going to be political support, and I don't know how else to put it, on the faculty for a bijural curriculum or not. That certainly had to be worked out. And curiously, and I have to say this, it's a little bit odd to say it, but it was the common law faculty that fundamentally were the principal supporters of the bijural program. Maybe it's because they felt they'd have to teach it, I'm not sure, but the votes were such that the common law faculty is substantially larger than civil law faculty, and they were willing to move ahead. So we got to work trying to think through what is it that we might want to do in terms of bijuralism. Will we simply want to show parallel developments between civil and common law? Will we want to see if we can unify, look at the, say, contracts, have a course that's in contracts and obligations, and try to find common elements and come to some synthetic notion of how they might perhaps be usefully combined, et cetera. These were very, very difficult questions that were debated at great length. Then there was the question of the joint degree. Should we offer a joint degree? Was it worth, and was it proper, as opposed to false advertising, to offer a joint degree? What goals could be achieved by that? And those questions had to be reviewed. And then finally, I felt that we needed a very strong, highly qualified, very well-trained individual to run the program. And I had the good fortune to meet with Olivier in Lyon, and you know the rest of the story. The last 20 years, I think, have been quite extraordinary, and I can't compliment this man enough, nor can I compliment Parisi enough for an outstanding Tucker lecture, but a lot of it learned when you were back here working with this fellow over here. And as you broke down the time frames, et cetera, in terms of the evolution of an organization, I was listening to you and smiling because I was in my own head going, yeah, 1, 2, 3, 4, 5, 6. And what is so exciting to me, because I'm an old man now, I guess, not really, but I'm 87, which is a little bit older than Biggie, 60 or 50 anyway. I am so thrilled with the progress that has been made. I think we are at this post-classical period that you talked about, where there had been this demonstration of the feasibility, capability, political support, financial support, et cetera, to make this thing move and move in exciting ways. And I think there's no doubt that it will continue to go that way as that happens. So for me, coming here after about 20 years or so, or 15 years being on the campus, and looking at this setup, and looking at all of you, and looking at the enthusiasm that this thing obviously has created, and thinking of all those trips that made us all, Lisbon and others, to Peru, and to Chile, and to Colombia, and to Argentina, and to Brazil, et cetera, et cetera, et cetera. You know, it was all worth it. I'm so happy that was done. I'm so proud of the faculty for moving in this direction, and I'm delighted with the leadership that my friend to the left has demonstrated. So it's a very optimistic message I'm giving, Vernon.
All right, we're going to throw you off here by not continuing to go straight down the line. I've asked Asya if I can speak next, and that's because of the many remarks that I want to make, the first have to do with the subject that Vivian and Professor Bermann brought up, and that is legal translation. For the past decade and a half, legal translation has taken up or constituted a significant part of my work as a legal scholar. I'm happy to say that I made at least some contribution to the development of what we've been calling civ-lit, and that began actually with our work on the Dictionary of the Civil Code, photographs of which you saw before, which is in fact an English translation of the Henri Capiton's Vocabulaire Juridique put together by Professor Gérard Cornu in France. And then after that, this has not been mentioned today, I don't think, but Alain, David and I translated the French Civil Code into English, and that's now posted on Légifrance. And then, as Michele pointed out today, our highly commercially successful translation of the French Civil Code into not only English but also Arabic. So let me first say some things to Michele. First, I want to thank you so much for clearing up a mystery for me today. You see, for the past 5 years, which is when that was released, I've been going to my mailbox every day waiting for a royalty check from LexisNexis, and it has not shown up yet, and now I know why. Thank you.
I told LexisNexis that they didn't honor their contract, so I considered that I took back the intellectual property of the translation, and that from now on I am free to use this translation as I see fit. And
including loading it into ChatGPT.
Well,
that's perfect. I'm all for it.
So yes, and I said that we had not received any payment, and they said we will pay you one day, but that day still hasn't happened. I'm very sorry and a bit ashamed of that.
Quite all right. I was just joking, of course. One thing that you mentioned in your presentation, Michele, is that we're very concerned, or at least the version of civ-lit, because there may be civ-lets, you know? The version of civ-lit that we were working with when we made our translation, we were interested in, among other things, exploring how other mixed jurisdictions, but specifically mixed common law, civil law jurisdictions, had rendered words from French into English. And you mentioned in specifically Scotland, South Africa, Quebec, it's also an issue there. Well, I want to invite audience participation now from specific members of the audience, but I want to pick up on Mariano's point. There you are, very good. How do we translate clause pénale? Yeah? How do we translate that? Do we translate it as penal clause? Do we translate it as penalty clause? Or do we go whole bore common law and call it liquidated damages? Well, I'm curious, Professor Cairns, what term do you use in Scotland?
Offhand, I don't know, but I will say that as an undergraduate, I wrote an essay rather long ago on circulatio poenae clause pénale.
Okay. Now, my colleagues in Quebec, in the Quebec, the English translation of the Quebec Civil Code, penal clause. So you stick very close to the what would be the cognate, right? By the way, that's another element of the civ-lit that we developed, which is, if possible, find a cognate in the target language of the word in the original language. And that's one of the reasons, among many, that we chose solidary instead of, for solidaire, instead of joint and several for solidaire. Okay. Anybody know about South Africa? I mean, I'm really curious about this.
Thank you. I believe in South Africa, it's also penal clause. I mean, because our link is with Dutch law, so
right.
We don't have this French term in our law. But I think penal clause would probably be right. Yeah.
Well, I want to thank Mariano for bringing this up, because this is a matter that I'd never investigated before, and I have to say that at least at this point, I'm inclined to agree with your conclusion that the use of our use, what is our use now? Stipulated damages does kind of fly in the face of civ-lit. It seems to me that penal clause would have been a much better choice if the sole point was to translate. But arguably, the point was not just to translate. I think Alain would have gotten into this if he'd been able to make the second part of his presentation, not just to translate the concepts from French into English, but actually create a regime of stipulated damages that was somewhere perhaps between civil law penal clause and common law liquidated damages. Yes?
Let me about the question of the penal clause. The reason why South Africa and Quebec apparently do not hesitate to use the word penal clause is because they're not concerned about why the amendments of 1983 were changed to stipulated damages. And that mainly is because of the common law approach generally prevailing, although lately the UK Supreme Court has been changing its views on that, that agreed damages to punishment are not the proper function of a civil law, which is compensation. And therefore, the reformers of 1983 here thought that they have seen Louisiana case law where, relying on the word penal clause, they have just simply invalidated the clause. Mm-hmm. Now, the problem of excessive damages in punishment, of course, is taken care in France and in other jurisdictions by giving the judge the faculty, the power to reduce excessive damages, something that common law countries will generally not do. They either avoid them or they upheld them. Therefore, there is a reason why the stipulated damages. And when the UNIDROIT principles in the International Commercial Contract, which is meant to be the contract law for the world, had to be drafted, the issue, of course, came up. And there were some concerns about that issue. And none of the drafters even thought about using the word penalty, because I knew that it would invite courts in common law jurisdictions that do not know better, that just simply to fulminate with nullity those clauses. And therefore, they agreed on damages for non-performance. I believe personally stipulated damage is much better word than that one. But in a way, and the drafters or the authors of the provision meant that, they want to avoid that question. It's neutral. Now, of course, it will be up to the Louisiana courts to determine whether or not if the amount of damages after many months or days of non-performance increase the amount of compensation, whether that penalty function is okay. French courts have said, yes, it is okay. And the expectation is that Louisiana courts will do the same. But having 49 jurisdictions that said that unless an anticipated estimation of the reasonable damages, then they will nullify them, the Louisiana legislature thought, well, just put stipulated damages. That's the reason why I don't think it's thoughtful to put penalty clauses, especially in Louisiana at least, and it wasn't in the UNIDROIT principles either.
I understand. And it's interesting you made the point just now that it's a fundamental principle of civil law methodology that we separate the punitive function from the compensatory function. So we put the punitive function in the public law, the compensatory in the private law, and that's exactly what I started thinking, Mariano, when you began your presentation. I said, why in the world did civilians ever call this a penalty clause? Because that's public law, not private law. And eventually the answer came to me. This is a penalty that's the result of private ordering. It's not a penalty that's imposed by the government, and that's why it could fit within the private law. It doesn't have to be relegated to the public law. Now, before we leave the topic of stipulated damages, Professor Bermann, he asked Mariano whether that's not a nicely neutral expression, that is not suggestive of a penalty, also not necessarily suggestive of a penny-to-penny replacement for actual damages. And let me offer my answer as someone who did not study the Louisiana Civil Law of Obligations until after the revision. Until I heard your lecture, I had no idea that any of the law that came before our provisions on stipulated damages, whether in the Code of 1870, 1825, Digest of 1808, had anything to do with penalties. For me, it was a neutral word. I took it at face value as a student of, the civil law in English, and I just thought of it as a completely neutral term. I'll let somebody else speak, but I do have some other comments I might want to make.
I have a comment. I was impressed with the enormous resilience of the civil law as represented by the people here. and the ability of each of us to look forward to using our tools to solve the problems to come, such as AI, all the other kinds of things like that. The second thing is the Louisiana Supreme Court has promulgated a rule that allows common lawyers to come into the state and weigh in on the common law aspects of the bar exam. Not the civil law, but the common law. So we are going inevitably to get a whole lot more common lawyers. The other thing that I thought has been interesting is the ascendance of the federal rules of evidence and of civil procedure in almost all common law states. If you go to Mississippi, they use the federal rules. You go to most other places. So that is a uniformity of procedure all over the country. And basically, that was my thought, is that we are, all of us, we are prepared to move forward throughout the 21st century into a new age. Congratulations.
Thank you. Return to the panel, Asya.
Okay, thank you. I have joined this panel at a very short notice, so I was not following conference contributions with a view of taking notes and summarizing and what's not. So, but an intuitive and immediate answer to your question, whether something surprised us or whether we learned something that we didn't know about, so would be in 2 points. First, I was greatly impressed by the level of mixity in this conference, and I don't mean just the mixity of legal traditions, but I mean a mix of everything, a mix of jurisdictions and representation, a mix of languages, time periods, sources, topics we covered, like all the books of the Civil Code, also the mix of disciplines and interdisciplinarity. So some presentations were connected to linguistics, like the translation panel. Some incorporated cultural studies, like that presentation on the Acadians and their view of the Civil Code. Some presentations were also about economics, like modern theories of ownership, etc. So, and this level of representation is really very impressive. And the second point that really impressed me here is the progress that the Louisiana civil law tradition has made in this 200 years. After the purchase between 1803 and 1808, the state of Louisiana was at the point of not being able to keep its civil law tradition. And now, 200 years later, we witness a fully fledged legal tradition with multiple revisions of the Civil Code, with civil law treatises, several law schools, international influences. And this conference is a great confirmation of independence and the originality of Louisiana legal tradition. Thank you.
Thank you. Michele. No? Okay.
Just a small comment, because you ask of the origin of the word pena, penalty. Well, it's a very strange story. It's originally a Greek word. It entered into the Roman atmosphere in the 5th century before Christ. We know this because it was present in the 12 tables, although being a Greek word, it's quite early. The original function of poena was to sanction. It was a monetary compensation that the victim of a tort could get in some very determined context. It was not made as a compensation, not only as a compensation, but also in a way to punish the doer. So it was an amount of money always. And the thing is that eventually, during the late Republic, because you could, through a special contract called stipulatio, you could basically pact anything. So, through stipulatio, some clausulas, some stipulatio bonellis were born just to punish one of the parties when they breached contract, beside any other kind of compensation. And well, that's kind of the origin. Another thought I would like to share is about translation, because translation is a fascinating thing. This brought to mind, this discussion during these days brought to my mind an old article of the 1920s, I think it was 1923, of Bronislaw Malinowski, one of the fathers of anthropology. During his experiences with the Trovian people in Melanesia, he asked a question: who owns this? And he got very different answers. Sometimes the answer would be this man, sometimes this clan, sometimes we all, the village. So finally he concluded that the question was wrong, because they didn't have a translatable concept of ownership. Another story of the same kind, Tsuda Masamichi. Tsuda Masamichi was an interpreter in late shogunate era, right before the Meiji Revolution in Japan. When Japan had to open its commerce to the West, they were subject to different treaties that made them obey the laws of the gaijin, the foreigners' laws, when they had a conflict between a Japanese person and a foreigner. So they didn't know what this meant. So they sent this guy, Tsuda Masamichi, long family of translators, they sent him to Holland in order to understand what these gaijin rules were. He came back. They got in Holland, they got this wonderful book that regulates everything from birth to the grave. That's the Dutch Civil Code of 1838. So they said, translate it. There were no words in Japanese, for example, for civil law. So he had to invent the words and invent, in a way, a tradition. Still today, minpo is the word you use for civil law in Japanese, and it was an invention of his. Words for obligation, for property, all these words were created in the act of translation. So translating is not just putting something in words, it's creating concepts. It's a very poetic act. That's why I admire translators. And, well, we have recently got the new Chinese Civil Code, which is in itself an act of translation, not only of transplant, but also of translation. And going with the post-classical period of our dear friend Agustin, well, post-classical periods are always characterized by mixture and expansion. I think the Louisiana civil law tradition is uniquely positioned to explain both common law and civil law to the rest of the world, especially to places like China that are eager to learn about it. I think there could be a very brilliant future, a Creole future in China. Maybe.
Thank you, Carlos. Let me tell you that I met Carlos Amunategui the first time in Amsterdam at a meeting of the European Society of Legal History. He was giving a paper showing the Louisiana influence in Japan. Agustin had made a map, a world map of influences from our state. We didn't have Japan. You got to color Japan, use the red. And Carlos is also one of the great Roman law professors in the Americas. Okay.
Just a very quick note on the translations of the Chinese Civil Code. I wrote a chapter on limited real rights in this new civil code, and I read all the 3 translations. With respect to my area, I found all of them unsatisfactory, so I had to interview a Chinese lawyer to help me to understand the provisions, and that really helped. So someone who is, you know, fluent in English, etc. So those translations also need to be improved.
And of course, Agustin, China is colored on your map, because there are significant influences. Michele.
So thank you for having the opportunity to participate to such an extraordinary conference, because frankly speaking, when I saw the program, I had no hesitation. And although on Monday I'll be teaching my class on comparative law in Torino, I really wanted to be here with you. For me, it was the opportunity, above all, to listen to your experience, because one can read books and articles, but to meet the people who have done the job, it's a completely different story. So I wanted to be in this room precisely to listen to your view of this important bicentennial for the Louisiana Civil Code. I must say that the code reached even Italy because Mr. Carlo Alberto, the King of Sardinia, had to codify the law in 1838. At that point, the Louisiana Code was the newest code in the world, and so they had to look at it. I cannot cite you exactly where and how, but it is attested by the preparatory work of that code that the Louisiana Code was consulted. It is, to me, important to reflect on the entire historical itinerary. From my comparative perspective, which is also yours, of course, the era in which the code was drafted was an era in which the common law was not yet stabilized, as one of you mentioned. That is to say, the common law that we have today as a term of comparison really didn't take shape until the last quarter of the 19th century, basically because Holmes started to say the civilian got it all wrong. And yeah, frankly speaking, that was his point in the book. And so there was a sort of retrenchment of the common law tradition by then, because as you mentioned, the previous period, we got a common law that was quite Romanized. And we all know that the great lawyers of the United States, Story, Kent, and so on, and no hesitation in drawing from the civil law tradition to deal with the common law tradition. So at a certain point, there is a breaking of the nexus, so to speak, and we get much more competition between the two systems. So my impression is that the date of the revision, the decision to turn to English, and so on, fits into a larger pattern in which the common lawyers have a much stronger sense of identity vis-à-vis the civil lawyers. And I think that is also the point where in England, we have a new generation of textbooks that do not refer anymore to the civilian background. We all know that the early English textbooks, Brian Simpson wrote about this, did use the civil law to build up a systematic treatment of certain parts of the law, because they had to turn away from the common law actions and provide a substantive approach to the law. Once the operation was done, they wiped out this part. One edition after the other, it turns to be more English than the previous edition. And I can tell you that I had a similar experience dealing with the impact of EU law on certain sectors of English law. I was a fresh graduate and went to Oxford to do my PhD work on the law of agency. And I was working in the library. At a certain point, written a letter to Francis Reynolds, that is the author of Boasted, an Agency, one of those common law library books, to get some clarifications. And this time it was him turning to me, asking, what is this story about commercial agency? What is commercial agency? Because you all know that in continental Europe, this is a way to do business. And the English pretended that they never had something like this, especially the indemnity that you have to pay to the agent because of the clientele that he has acquired. So, so Reynolds, that was a very kind man, started me how this was applied, and started asking me to provide cases from the continent to show how the law was applied, and eventually asked me to co-draft the chapter on commercial agency in that for 2 or 3 editions. I even got the royalties that were substantial because he was a very honest man. I got, I think, with my huge surprise, £1,000 for co-authoring a chapter of that book. That gives you an idea of the money that they make with these big professional books. But at the end of, well, I'm simply telling you how it went. But once the English courts started deciding cases on the English application of that directive, the foreign material went out. The materials I had provided stayed for 1 or 2 editions, but once you are up on your own feet, that went out. And perhaps it's good, because once you acquire self-confidence and you're able to work with your own methods, why to turn elsewhere? Especially why to turn to a fresh Italian graduate. But in any case, let me return to the wider picture, and let me say that Louisiana is one of those jurisdictions we have to consult when we work on private law, on the private laws of Europe, outside the circle of European instruments, because that is uniform. It's in 24 languages, but the assumption is that it's uniform legislation. So European law does not cover everything, and then we have the problem of relating to each other and try to understand to each other across the entire private law domain. And unless we rely on our own national languages, which are not of great help if we have to communicate across boundaries, you have to invent a common language for Europe. For a long time, this was French. I don't deny this, but the magnitude of Europe nowadays, including Eastern Europe, has tilted the axis, so to speak, and we have to take into consideration that younger generations are basically trained in that language. I'm not claiming that Europe will not remain plural in terms of languages. Even in law, it will remain plural. But the need for a vehicular language is still there, as Latin was. This is a reality, but in order to build this vehicular language, we desperately need the experience of the jurisdictions that have already done this job, have already turned a civilian system into a civilian system presented in English. And I think the amount of reflection that you showed throughout these sessions on this story is rarely seen in Europe, except perhaps in very specialized circles of translators. Translators have done this job. They know it. It's us, the lawyers, that in most cases are still struggling with this. And I can tell you there are many Italian lawyers that simply think that Italian law cannot be translated into English. They forget that it is regularly translated into English to present cases to the European Court of Human Rights that has just 2 languages, French and English, and to present cases to the European Court of Justice. So I think we are lagging behind compared to your jurisdictions in terms of awareness of these problems, of this problem. And I'm simply grateful for having the opportunity to have been part of the audience in these debates. I'm a culprit as far as codification is concerned because I edited a book on the civil codes in the 21st century, published by Springer last year or 2 years ago, co-edited with a Chinese colleague. And it has 3 chapters on China. I was very reluctant to take upon myself the task of co-editing a book that would have to cover several jurisdictions. I think we did 16 or 14 jurisdictions. But I learned something interesting. I was asking myself why the Chinese do want to have this civil code. Of course, for them, it was an important achievement. For them, an achievement of, in many ways, of extraordinary importance. They know that it's defective. They know that it's a first attempt. They're not claiming that it's absolutely perfect. When I start asking them, they had an idea. We have to produce something that is at least original in some respects. And they spotted to a weakness of the traditional civil codes, that is to say, the rights of personality were sort of marginal as a subject compared to patrimonial law. So the first idea was to have a book on personality rights in the civil code of China, not a place that we consider usually as outstanding in terms of defense of individual rights. But on another level, the reflection was even more interesting because the other answer I got is we know that we are not all that good in terms of defense of individual rights, but if there is a chance to make a little progress in this respect, the chance is given to us by the civil code, because the Constitution of China is entirely political. If we entrench in the civil code some personality rights, then we have the hope that the courts will listen. And in a way, this is an interesting message about the possible validity of the codal form, even in an ambience that no more, gives to it a central place, because I fully understand that litigation today, in many cases, does not turn around the civil code. But in any case, that is the story.
Michele, you may be interested, maybe you have seen this, but in the Journal of Civil Law Studies 2 years ago, we've published the English translation of the Civil Code of the Popular Republic of North Korea. Do visit this. That's a curiosity. I pass it now to my brother, Professor Davrados.
I yield my time to the audience. Do we have
your time? Remember, you are co-moderator.
Yes. Do we have any questions or any comments? Yes.
Really enjoyed being at this conference. I've learned an enormous amount, so much I can't really quite digest it. It's like eating a great meal that you have to think about it and it settles. I do have a question about the relationship of the civil code to the courts, to the judiciary, particularly in Louisiana. So the great English legal philosopher H.L.A. Hart talked about the nightmare and the noble dream, right? And the nightmare was courts exercise judicial review too much, right? And they strike down statutes and they limit statutes. And the noble dream was they basically don't do very much. Once in a while, they'll intervene. and they'll improve a statute or strike it down if necessary. So Louisiana, you've had some great judges like Albert Tate, who interpreted the code very effectively, and I'm just interested in your perspectives on the future, what the courts are going to do with the civil code. How are they going to frame it and reframe it, and are they going to do it? So I'd just be, all of you know a lot more about Louisiana law than I do, and I'm really interested in what you'd have to say about this, about the courts and the civil code. So thank you.
Well, I'm going to offer what probably is not a comprehensive answer, but just a few bits and pieces. I think it's very important to recognize that at the current moment, we, from a civil law point of view, are in very good shape insofar as the state Supreme Court is concerned. And that's because our Chief Justice, who is a Francophone, fancies himself something of a civil law aficionado. Yes, and so when it comes to the interpretation of the code, he's all about employing traditional civil law methodology, recognizing distinctive means of interpretation, also sources of law, et cetera, et cetera. And I think, in fact, for the past several decades, going back to the time that people like Albert Tate came onto the court, again, we've been in good shape in the sense that the courts, unlike what they were doing back in the early 20th century, were not ignoring the code at all, but were recognizing that it is the primary source of law. And then, as Nick just mentioned, since that time, our courts have acknowledged that the civil code is not a statute, that it is, in terms of the methodology employed to create it, but then also, for the same reason, the methodology that should be used to interpret it. It ought not to be interpreted the way that, Nadia mentioned, where you, Nadia, how at least the English, when legislation started to come out in the 1400s or so, would interpret the statutes narrowly to preserve the common law. There's nothing like that in Louisiana, at least not since the civil law renaissance, which started in the 1930s. Somebody have something else they want to add?
I would like to share. I was appointed on Monday. And either two or three of the people, this was their first day. It was the hottest panel we'd ever seen. I practiced before the Supreme Court a lot, and the quality of their opinions has improved greatly. Justice Weimer basically said that he would go after statutes and render justice, and that basically the legislature beware. We had discussions about all kinds of things on that, and I was incredibly impressed. It was the hottest panel I've ever been before, and I think it bodes well. And all of you are the backstop for the civil code, and with your writing and your teaching are going to help improve the law in Louisiana, that the practitioners such as I can advocate a civil law tradition. Thank you.
Could I ask Randy a question? Randy, I'm going to probably be thrown out when I raise this question because it's going to be implicitly pro-common law. Is the civil law negatively impacted or in any way disempowered from being what it might be if most of its principles were put in place well before even the ones in the codes, even before the Industrial Revolution, number one? And number two, how do you feel when you look at the whole body of law of the state and you find that this much is civil law and this much is common law?
Well, I believe my uncle over there, Alain Levasseur, referred to himself as not just a civilian, but a stalwart civilian. I'd call myself a romantic civilian. And so the fact that our law, if you consider all of it, not just the private law, but also the public law, but even within the private law realm, especially if you look at non-civil law, the commercial law is now predominantly Anglo-American, does cause me a tinge of pain. But I don't think that just for that reason there's anything wrong with the system that we have. I think the system that we have, which is very mixed, to use that term, has been adopted for the most part for sound reasons. Now, your first question again?
The first question, let's see, was one about the fact that most of these codes that we're looking at are either preceded by or were themselves in pre-industrial times,
Right.
pre-industrial revolution.
Right, and indeed, if you...
With the implication of that being that the values of those societies are probably fundamentally modified in the period of time moving from pre-industrialization to post-industrialization, that the idea of deifying the wonderful elements of the civil law strikes me as something that needs to be examined. We've had a number of discussions of what's the purpose of codification. And there are many answers that can be given, but one of them was that they're reflective of the fundamental value of the social system from which they derive. And if the fundamental values are ones that date back to a pre-industrial revolution time, I'm simply raising the question. Maybe that's the problem. Maybe trying to conduct, for example, international business the way it's done today, as the way it was done in 1960 or 1860.
Or 60 BC.
I'm sorry?
Or 60 BC.
I understand. You can go all the way back. I mean, is it illogical to wonder about the potential discrepancy between the consistency of pre-industrial reasoning as it relates to activities that are predominantly driven by commercial structures and industrial structures that went around it?
That's an entirely legitimate concern, but I would say that it is a concern that is shared by policymakers in every modern civil law jurisdiction today. So let me start by saying, to the extent that we still have in our civil code a lot of rules that are straight out of Justinian's Digest, this is especially true in the field of property. The reason that we still have them is that they've stood the test of time. You know, to have in our numerous clauses, John, something called a usufruct, where we pair off the usus and the fructus from the underlying abusus, actually still works for us today. And I would say that that's true of a lot of Roman law. It was just designed in such a way as to deal with problems that haven't really changed since that time. Commercial problems in particular and property problems. The other thing that I would say, to get back to my first point in responding, is, again, if you look at the civil codes around the world today, including the Civil Code of Louisiana, what you will see is a significant amount of updating of the rules of the civil code in order to take account of the various kinds of transformations, social, economic, and political, that you've been talking about. Perhaps the best place where you see this in the Louisiana Civil Code, although I do have some concerns about the technique that was used in some instances, is in Book 1, the part on family law. You compare Book 1 of family law right now with Book 1 family law of the Digest of 1808, and you will see very little correspondence. The law of tutorship is still the same. The law of curatorship has been fundamentally transformed now into something that was taken for the most part out of the Uniform Probate Code. And then when we get to the parts of the code on marriage, but more particularly the relationship between between parents and children, child custody, for example, child support, for example, again, the rules there reflect, in fact, I would say, the values of the day. And so my point is, it's not like those of us who are civil law enthusiasts are saying it was good enough for Justinian, or maybe even back to Papinian and Ulpian, it's good enough for us now. No, it's only good for us now if, in fact, it fits our contemporary social, political, and economic context. Now, having said that, I will say that I think we still have surviving in our codes some rules that go back quite a long way, maybe not all the way to Rome, but certainly to France before the Code Civil, in particularly in the law of successions, that I don't think fit our contemporary situation at all. And I'm glad that my mentoress, Catherine Spade, is not here to hear me say this, because I would be in trouble, but I'm going to say it anyway, and Missy knows exactly where I'm going. Under our current law of intestacy, married person dies, his separate property does not go to his surviving spouse. It goes to his next biological kin. It goes to his parents, it goes to his siblings. If he's got both, then it goes to usufruct in one and naked ownership in the other. And if he doesn't have any of those, it still doesn't go to the wife. It goes to the other ascendants. She comes in only after that. Now, you want to talk about a rule that is out of touch with contemporary social values. Whenever I teach successions, or indeed any course, because this comes up over and over again, I ask them, if you were married people now, or those of you who are children of married people, if one of the spouses were to die, who would get all of the dead spouse's property, including separate property? And they all say the surviving spouse. So I think that may be a case of inertia, you know, where having codified the law instead of having, for example, to go to, you know, across the channel to the English common law, leaving it up to the judges to adapt it, might have stood in the way of a development that really would be advantageous.
Allow me to come with a counterexample in the law of obligations. I teach international business transaction, and some rules inherited from canon law, Roman law and canon law, pacta sunt servanda, the insistence on consensus, have won the battle of forms, if I may say. The common law has this rigid approach, mirror, image rule, etc., which makes it entirely artificial as to what the content of the contract will be. If you look nowadays at the Convention on International Sale of Goods, at the Unidroit principles, they favor the consensus-based approach. And anything that has been negotiated by the parties is going to be in the contract. If there are conflicting documents where things do not accord, this is left out because it's not part of the bargain. Here is an example, and there are other examples. You know, IBTs, and George Bermann certainly has his own examples. The UCC adopted the rule of that offers can be irrevocable in some circumstances. There are multiple examples in the area of business where the civilian approach sometimes wins it over common law solutions.
I want to suggest a partial answer to your question. When I think about when things and how things changed in the Industrial Revolution, when I step back, I think that's when bodies of law other than civil law came to the fore. Certainly in the countries I know, that's when administrative law began in earnest as a post-industrial revolution body of law. And I think some of the challenges that arose at that point in time were addressed through bodies of law other than the civil law. And I think that reminds us a little bit about the need to put all of this sometimes in a larger perspective, because the civil law addresses a certain range of problems, but other bodies of law address others. And I think when I think of the controversies that arose in the post-industrial age, I think a lot of them went to public law, broadly construed. And administrative law, in particular, it certainly began in the United States in the late 19th century. That's when we created our administrative agencies. That's when administrative rulemaking started, and that's how social and economic ills were primarily addressed, in my opinion. And I think that took the burden, to some extent, off of the civil law.
Questions about the research?
I know. I don't know.
May I add some comparative perspective on this? So in my research, I studied the civil codes of Quebec, Louisiana, and Francophone Switzerland, and they date anywhere between 1821 as the Swiss Canton of War and Quebec Civil Code of 1866. And they are all very similar to the French Code. So the provisions of the French Code fit well highly commercialized Geneva or agricultural Fribourg-Valais. Capitalist Quebec at the time, slave-owning Louisiana. So those provisions were flexible, so they were adoptable to the societies and to the requirements. That's one point. And second, not everything can be regulated by law in the area of economics. So you cannot just legislate for a new society, for new values, for new economy, new politics, etc. So the relationship is more complex, and it really invites some interdisciplinary studies.
Agustin.
Yes, thank you very much. So in the past days, we were looking into legal science, and legal science requires to look at how the law was, how the law is, and how the law ought to be. So the lege lata and the lege ferenda. And we touched upon that in the different panels. And I would like now to invite for an exercise. First to the people in the panel, and then open it to everyone. Imagine that today we are celebrating the 225th anniversary of the Louisiana Civil Code. So I'm not going to go 300 years. I'm going to just go to 25 years from today. What do you think you would find in the program of such an event when you open? What would be the themes that you think would be on the agenda for that period? That's why I open it also to the public to give some space for thought. Thank you.
Let's play the game. Who wants to go first?
My input
Carlos.
would...
Oh, yeah, sorry.
Just very short, one line. Animals, things, or persons?
It's a comment that's sort of cutting the chain, but it's to Randy Trahan. A spouse is not a blood relative. And I remember when there were changes in the question of obligatory inheritance, to my mind, and it comes from the perspective of maybe it's tribal, mostly accumulating wealth, and given this age of divorce, to my mind, it seems more logical to focus on the blood relatives.
Okay, this question is a very cool question because probably we can, some of us, well, if I keep smoking, I won't, but some of us might be able to see and check out what we get. Okay. Old things tend to persist. Think of the, I don't know, in the world of 2050, probably that we won't have, I don't know, iPhones or stuff like that. Probably artificial intelligence will be something very well acquainted and very well regulated, and we will know what it is. But we will still have books, tables, chairs, and pens, probably. Some of the subjects we're going to be discussing in 25 years, we already touched them in this conference. Probably we will be still discussing this Lavergne manuscript and its influences and the influences in other codifications and in the Francophonie and all this. We will probably still be discussing this because this is tradition and tradition persists. The world of Cicero is very different from ours, but we could discuss some of his legal problems still today, and we do. Oh, will there be some new, very extremely new things? Well, probably I think, for example, neuro rights will be here. That's the scary thing about putting a machine in the brain, yes. In fact, law on neural rights is in force now in California, another one in Colorado, and of course, well, the Chilean constitutional reform, well, I wrote that, so it's there. Neural rights probably is going to be big in 20 years, 20, 25 years. But the main problems will be basically the same, I think.
You mentioned Delaverne volume, but in 25 years, AI would analyze the Delaverne volume, all the tables of correspondences and sources and Batidza's tables of correspondence, and would eventually tell us where this all comes from, at least textually.
Yes.
I just received a comment from one of my editors on my AI chapter, my legal writing book. I'm including AI, and I think one of the things that's going to change is what we do as lawyers. It's already changed. There are massive machines that draft contracts now, so document review has been reduced to rubble. I don't know what our first-year associates are going to be doing if they can't do document review, which is enough to kill anybody's brain. But one of the things that will remain is that there will still be a need for lawyers who can negotiate and deal with compassion with other people, with understanding, with being counselors, not what I would refer to my students as law dogs, but counselors who will counsel their clients on the best way to deal with a problem. Because we've already got machines that draft contracts, we've got machines that can draft litigation documents, but what we still need is the human element.
Can I have a brief go, bringing Umberto Eco into the conversation? He has identified 3 objects that he describes as perfect and have not changed over time. There is the comb, you can go do excavations, etc. It says all as the world is. Scissors, apparently a perfect object that has never changed. We still use scissors. And the third one is the book. The book is perfect, doesn't need to be plugged in, doesn't need to be... And codes are books. And I'm convinced that in 25 years from now, we will still have codes.
You know, I'm reminded by this conversation about how, you know, problems remain. There's this quote that many of you know, I'm sure, from a Supreme Court of Louisiana decision that says, "The past is not dead, the past will not die, and the past is not even past." That comes from a Louisiana Supreme Court case you probably know.
And from Faulkner.
Okay. Well, they borrowed the motor boats.
Yes.
They didn't attribute it. Pleasure.
Thinking about the many issues that are going to come up in 25 years from now and picking up on the question, I think that I'm going to follow up on Chancellor Costonis' point about the legal education. I think this is an issue in which there is much room for improvement. And I think that from what we have heard in all these conferences these days, much credit has been given and mention have been made to the Louisiana State Law Institute, but the Louisiana State Law Institute counts among these ex officio members of the faculty. And all the faculties of law schools of Louisiana have been represented in the panels here. And those, many of those, if not most, have been students from also faculty members, and I've heard Joseph Dainup, I heard the name of Athanasios Giannopoulos, or Saul Litvinov, and many others, who are those who have been responsible for education given to what later on was a justice of the Supreme Court of Louisiana, or from the Federal District Court in New Orleans, or the Fourth Circuit here. So I think that what I think it's important to think about is, how can we improve on that legal education? Chancellor Costonis spoke about the bijural education. Remember, that was very much on fashion in Quebec and in Louisiana, graduating students with 2 degrees. One, the degree for generally on the civil law, another on the common law. My question is, who are your students? Are they thinking about handling disputes between Lafayette, Monroe, and Baton Rouge? Or are these people who are going to be dealing with interstate and international transactions too? Because if that's the case, they really have an advantage. And we that had the opportunity to study in this law school had a privilege, really, of really getting this type of education that we would not have gotten in Argentina, where there's only one civil law jurisdiction, or in New York, where there's only one common law jurisdiction. It's a great advantage. So my question is, who are going to be the students 25 years from now? What can we do better? And all of them in the table are experienced academics. And I would love to hear from them about what their ideas are about, not so about global legal education, but at least how would you change in your curriculum, in your law schools, and how would you train better the students, the lawyers, the judges, and the arbitrators of tomorrow?
I think you need to train people to think. I have practiced all over the country. And the way I do it is I think about stuff, and I read the books, and I'm courteous to the judges, and I'm prepared. And that's what I think all of you are preparing your students for that kind of opportunity where there are no barriers.
You know, Alex, I'm reminded by your question of the time when, at my law school, unfortunately it hasn't continued, but we decided to create a course in the spring term of the first year that would take every first-year subject that students were studying and internationalize or comparatize that subject. So the contracts became international contracts, and they raised choice of law issues. And the civil procedure started incorporating international arbitration. In other words, the very conscious effort to take the subjects that American students study in the first year in a purely domestic context. Every case a first-year student reads is an American case. And usually a case involving only one state in the United States. So there aren't even conflict of law questions within the United States. And a very deliberate effort was made to take every one of those subjects, whether it was torts or civil procedure or contracts, and develop the international and comparative dimension to them. Now, I think that's a partial answer to your question. It's, comparatizing and internationalizing our curriculum that will result in broader horizons. I think there are things we can do from a curricular point of view. I'm sorry that little experiment has not continued, but it was a very valuable one.
May I follow up on that, George? I think there are two, perhaps three essential reforms that we need to incorporate into legal education in our world. Number one, and I don't say these are easy reforms. There's so much resistance to it. I've tried 5 or 6 times in my career to convince my faculty that we ought to do this. Number one, we need a global introduction to law in the first year, in the beginning. What do I mean by that? Just an introduction to all of the institutions, public, international, private, state by national, federal, all of the institutions should be like a roadmap. And we should explain in that global introduction what each of them does briefly. This is And this is the common law student, this is the civil law student, this is the international student, this is everybody doing the same thing, being on the same page. I know that that sounds simplistic, but it's not. It's really difficult to do. It would be a revolution, because most of these things are added at the end of legal education, or never added, never gotten to, only through electives. Would you learn anything about the law of the sea, perhaps, or to learn about the work of the International Monetary Bank, or all of these things come at the end and haphazardly. I would start in the beginning with that. Of course, you need someone who can teach that kind of thing. You need someone who is not a non-specialist in one area and is afraid to move out of his specialty. This is part of the resistance that you'll find to ideas like this. Secondly, I would start comparative law in the first year, in every subject. It's not too soon. You should infuse comparative law in every subject that is taught at the law school. This is whether it's public law, whether it's private law. And I would say this is the hardest type of reform to bring about, because we never do these things. But this would make really, you spoke about the advantage of coming to LSU. Of course you have that advantage. Think of the advantage you would have, however, over other law students all over the world if you had a global picture of the law and a roadmap, and you've been down that road. And you could converse, deal with your international counterparts so much better, because you would have double, triple passports to discuss the law and to be able to handle problems. So recently, I promoted this idea at my university, and we wrote the roadmap to the global introduction, and we got to the point, well, who's going to staff that? And I said, well, I'll do one section. We're going to do all the students. We have to do that in sections. I'll do one section. Another person said, I'll do another section. But they said, well, who'll do the third and the fourth? And the idea was dropped.
You're giving me the idea what could be a forthcoming conference, Vernon. Why don't we have LSU, Tulane, Maastricht, Bucerius in Hamburg, University of Luxembourg, all these schools that have a sort of global and comparative curriculum, and exchange on our practices. What is it that we are doing? What is it that we aspire doing? I think we have a lot to learn from one another and could help. Vivian.
Yeah, so Alex, I completely agree with you, and I think LSU could really be attracting students from the best and the brightest, and they probably are already, but even more so. I remember when Nicolas Cassirer was just implementing the bisystemic program at McGill, he invited a group of comparatists to observe the classes and to comment, and he mentioned that one of the byproducts of their new curriculum, which was to have every student be sufficiently conversant in French and English to be able to at least understand a class in each language, and for each professor to be sufficiently conversant to be able to answer questions or to understand questions from students who are Francophone or Anglophone, was that to the school's own surprise, when they graduated, they were in great demand by the biggest Wall Street law firms because they understood two systems of law. They were, very much in demand, and which would also be true for international arbitration. If you can represent a client even if the client is just common law or just civil law, but in front of the three arbitrators, one of whom will not be from your system, but just explain it in a way that the other can understand. What an advantage, what an advantage. So if only this were possible in the United States, throughout the United States, I think in Louisiana, there's maybe something like that would be possible for the whole curriculum. But I so agree with you. I think one of the big problems for students in the United States is monolingualism. But to remedy that, when do you remedy? You can't start in law school. It's a little late.
You mentioned McGill that I had omitted on to my list. I have a special message from Justice Cassirer, because he's on the Supreme Court of Canada now. He wished so strongly to be here. He was, of course, invited, and the calendar is just a hell of a calendar. He couldn't free himself just to be there even half a day. I would add to what Vivian is saying. Louisiana is mixed, of course, because of its law, but also its geographic position. We're a sort of border between the United States and the North and the global South. And this is also a position that we have to reflect about. And I know John Costonis had put a lot of effort in trying to develop a strong and robust Latin American program. But these are things that we must be aware of where we are on the Gulf of Mexico, or if it's called in a different way, it's a Gulf with only one hole.
Going back to the need to train more internationally and comparatively oriented students, so this is something that is happening inadvertently and intuitively in the Commonwealth Caribbean now at our faculty. The use of AI by the students is all pervasive. They submit all tutorial questions to AI, but because AI tools are not sufficiently trained in the Commonwealth Caribbean law, because it's not well reported, they come up with the answers based on American law, on Canadian law, on British post-independence cases, and that's where fun starts. When they produce those answers, you ask them, okay, why are you using an American case as authority? And they say, oh, sorry, miss, I'm wrong. And they say, no, no, no. If it is a good authority, if it addresses the issue, it could be a persuasive authority, but look at it, you distinguish facts, look at the rule, and think if it could apply to the Caribbean if there is a gap here. So I think other jurisdictions will follow. Many of them would submit those legal problems, and it can come up with anything, EU law, and anything that is available there. So what we are doing now, we are asking them specifically to use AI, but to reflect on the answers that come back and to say, okay, what are the limitations of AI, whether it's useful or not. So this is something that should be considered. We cannot avoid it. So they will be using AI, and we should teach them to use it responsibly and to their advantage.
I think we have 7 minutes left on the time. Michele, I see you have the microphone in your.
I'll be quick.
Oh, no.
I have much sympathy for the point of view that was expressed. That is to say, to try to have a more open approach to other experience, and especially the point you made, Vernon. That is to say, to try to have such a course. We have had such a course in Italy because the tradition of René David, major legal systems of the world, has been maintained. And it's a compulsory course for all students. This opens the gate for more specialized interest in comparative law or international law. And I must say that overall, students love this type of course. For them, a first encounter with the foreign law is a way to, as we all know, take in more relative terms their own law, the law that they have thought, they have thought about for the entire first year. We offered this in the second year. It could be done in the first year as well. I don't think it would be dangerous to do it. This is an alternative to the Roman law that is still on the books of Italian law faculties in a way, because it's much more dynamic. That is to say, if you think of it, traditionally, distinguished faculties like Oxford, Cambridge, and so on were offering Roman law precisely to offer at least one other legal system to the students. But since this tradition has died away, nothing has really replaced this type of teaching. So one could think of a course like that that would have the same type of meaning that Roman law once had. That is to say, to open up a little bit the views of the students about another legal system. That was the system that everybody was able to teach, you know, at a certain point, but it was not positive law. And so my invitation is to rethink that tradition. And I think your suggestion, Olivier, to try to convene a conference of internationally oriented faculties to decide what could be the state of the art in this field would be important. It is true that we have discussed at the International Academy of Comparative Law the same theme, but the fact that law faculty takes the initiative makes a big difference from my point of view, because it takes the discussion out of the purely academic environment and it brings it where it counts. Law faculties, what are they doing now? And I think it could be a very instructive conference for Europeans as well.
I have one last thought. I'm told there are 5,000 children in bilingual courses in Louisiana. Just think what it's going to do when they hit your law school.
We are having a reasonable number of students at this law school who have been in the immersion programs, who know French, who know Spanish. And we have a Hispanic student law society. We have a sort of club français. We have a café français every other Friday where the students are meeting. And we are thinking of creating a Spanish legal terminology class. And I have a conversation going with a few alumni who are very active. We have also a study abroad. Unfortunately, not many students want to go. But this year, I have 3 students who apply to go to Austral University in Buenos Aires. And they ask, well, by the way, could you give us the list of the classes in English? It happens that they have no classes in English this year. And they say, never mind. We know enough Spanish, and we're going to do it in Spanish. There will be one in Lyon, and one in England, etc. It's not much. It's not many, but we have, and we need to cultivate this and develop activities. We sometimes, with the Cher Sangor, we had the former dean of l'Université de Montréal give a lecture in French in our building. It was well attended. Alain has invited several professors teaching in French in his class, and we got to keep doing this. Even if numbers are small, they make a difference. It's not so much the number of people we touch, but we need to offer something for the few who wish to have it. Where are we time-wise? 5:58. Is anyone wishing to use the last 2 minutes? Okay. In that case, I will use 10 or 20 seconds to extend our warmest thanks to our colleagues on this panel for elevating even further the level of our discussion. My warmest thanks to all of you who have been presenting at this event. This has been formidable 2 days, right? For you who came to listen and to discuss with us. Thank you very much. And of course, the students who have facilitated the event, Katie and the others, Aurore sitting there back, and thank you very, very much. And